Hello everyone, welcome to Back to Basics, Common Sense Law with yours truly, Preet Gill. Think about this scenario. Have you ever been at a party where it's really crowded, your aunts and uncles, your neighbors, your friends, everyone's there to celebrate a birthday party or a wedding. You know, there's kids running around, there's elderly people that are in walkers, people are dancing, people are drinking. I mean, you know, from a lawyer's perspective, especially when it comes to injuries, that could be a nightmare. What if somebody falls or somebody gets injured? What if a child ends up in a place in the house that was restricted and they find old machinery or they find something that they should not be playing with, and as a result, they get injured? Who's responsible? What are the consequences? You know, in fact, half of the accidental deaths that occur in the home are as a result of a fall. And these falls are usually on the ground level. Because when you and I think about a fall, we think maybe stairs or the second floor or uneven terrain, but that's not the case. It's usually a flat surface. So accidents can happen anywhere at any time. What do you do if you are the homeowner or if you're the business owner? How do you protect yourself? What are some of the steps that you can take to prevent an injury that could be fatal, right? And it could be a tragedy. Or what if you are the victim and now you feel that you're in this awkward situation because maybe you did get injured at a very good friend's house? How do you approach the topic? What are your rights? Who's going to pay for those bills? These are some serious issues and they happen more often than not. And it's better that if we all know what our rights are. So today's episode, we're going to talk about premises liability. So we're going to go into what are your rights if as a homeowner and what are your rights as a victim. So don't go anywhere because right after the break, we're going to look into what is everyone's rights. I'll see you guys right after the break. Welcome back. What happens if you go to your friend's house at a party and you get injured? You may have fallen down the stairs and now you have medical bills and you just need to pay for these expenses. How do you approach that topic with your friend and who's responsible? This is what we're going to go into today. I just want to take this opportunity to let our viewers know that please keep in mind we are New York-based attorneys, so we will be talking specifically about New York State law today. But for all my viewers that are not in New York, thank you so much for watching, and I really hope that this show will at least give you some idea as to what the laws may be in your state. I would always say please consult with the lawyer in your state because some states may be completely different, but at least it's a good way to check out because we'll have some good tips on what you can do, and I think that could be a universal common sense as to how to protect yourselves even if you're a homeowner or a business owner. So without any further delay, I wanted to welcome our guest, Thomas Reimel. Thank you so much for coming from the law offices of Helen Dalton and Associates.
Thank you so much for having me.
Thank you. You are our personal injury specialist, so we really, really do thank you for coming in and sharing all this information. You know, a lot of our viewers are homeowners or business owners, and I think that it can be a very scary thing if someone can get injured. So, what can cause an injury? Like, what is a condition that can cause injury?
Well, just because someone comes on your property and becomes injured doesn't necessarily mean that you're going to be subject to a lawsuit, but it could mean a lawsuit. In general, a successful lawsuit against the person who owns a property or controls a property as the tenant, really that requires what's known in the law, at least in New York State, as a defective condition. And a defective condition can mean all kinds of things. It can be anything from can be water or another liquid that causes a slippery condition. It can be an uneven floor. It can be, it can be something that's actually left on the floor, like a extension cord or rubbish that's on the floor, or even a defective design. If a stairwell or something is not well lit, or if there's no handrail, all of those things can give rise to what's known as a defective condition.
Well, I guess in my house there's a lot of defective conditions with my son's toys everywhere. Like, you have to tippy toe, but I see what you're saying.
Well, and there's another important distinction when we talk about defective conditions. Now, it can either be too small or too big to cause a lawsuit. And here's what I mean by that. A defective condition that is so-called a trivial condition, that is something very, very small, even if a person does get hurt by it, that doesn't mean that you're liable for it. In other words, you can't sue over something that is so small that the person who is in control of the premises can't be expected to fix it. So a good example would be, say the floorboards are uneven, but it's only, say, 1/16 of an inch.
Right.
That's not going to do it. It has to be, there's no exact definition about what's a trivial condition.
Right. But this is just an example.
But that's just
giving.
an example. Yes. So a trivial condition, because while the law is that you need to make the premises reasonably safe for the foreseeable use, but you're not a guarantor of the safety of everyone who enters the premises.
Right.
So it needs to be reasonably safe.
So what's the other spectrum you said?
So if it's too small, it's a trivial condition and you can't be sued successfully for it. The other one is the exact opposite. This is a defect that is what's known as open and obvious. And it's exactly as the phrase suggests. If something is so big and obvious that it's dangerous, a big old pit, that's 3 feet wide. Now, while I don't recommend that you have such a thing in your home, obviously, but if it's an open and obvious condition, the reason that's a defense and the reason that you probably can't be successfully sued over, the idea is that if it's open and obvious to the person who comes on the premises, then they really shouldn't have encountered it. In other words, if they decide to go ahead and navigate this open and obvious danger, they've assumed that risk. And it's not really your fault that they did something that was so obvious.
So like an example, if you come into somebody's house and there's a giant hole in the middle of the house and there's signs all over, there's a hole, and you still decide to walk through it, that's open and obvious. And if you decide, I'm going to still walk through this and fall, then there's the homeowner or the tenant who's in control will most likely get away with
That's
not
right.
being liable.
They'll most likely be found not liable. Now, anybody can sue anybody over anything, but today I can only talk about what might be a successful lawsuit where a person would be found liable versus not. And if it's really, truly an open and obvious defect, you probably will not be found liable if someone gets hurt from such a defect.
One of our law school professors used to always say to the class, can you sue? Yes, always sue. But will you be successful is the question, right?
Yes. Two very different questions.
You have said a really good thing. But okay, so I understand that you have to take reasonable care for something that's foreseeable. What does that even mean? Like, let's say my friend decides to surprise me in my house one day. I don't know that she's coming. She sneaks in, right? And then she gets hurt. Am I responsible for that? Because she wasn't invited, technically.
Well, like so many legal questions, the answer is maybe.
Okay. Don't you love lawyers? Maybe.
We can never give a straight answer. What I can say is that it's all about foreseeability.
Okay.
So, for example, if you know that kids are always or people are always cutting through the corner of your yard, it doesn't really necessarily matter whether they were invited or even have permission or even allowed. If it's foreseeable that over time, weeks, months, years, people have continually gone through that corner of the yard, if there's a gopher hole that someone twists their ankle on, you might be found liable for that because it's foreseeable that people will use that pathway. Right. On the other hand, if someone's a trespasser, if they're coming to burgle your home, it is extremely unlikely that the duty to someone who has absolutely no permission, someone who is a trespasser, someone with no lawful permission to be there, you owe at most a slight duty of care. Basically, you can't create a trap.
Okay, so you're saying that if I decide to protect my house because people keep robbing it and I decide to dig a 4-foot, ditch so that they can't enter, and this robber who's coming to rob me falls and injures himself, I could be responsible for that.
There is case law to that effect. It's surprising to people that you owe any duty to someone who's there to do you harm. But the idea is that the protection of property is less important than life and limb.
Right.
And so while you don't have to make sure that if a robber comes and slips and falls on your carpet, they would be unlikely to be able to sue you.
Okay.
But in your example of a pit that's lined with spikes, you just can't do that.
Hey, there are a lot of people that are paranoid in this world, and they will set up all kinds of traps and locks in order to keep the whole world out. And if someone can get in trouble, then you could be looking at that liability. So, okay, what are some of the common types of defects that you would normally see in a house?
Well, it runs the gamut because it can be almost anything can be a defect if someone gets hurt from it. But obviously some of the most common ones are a slippery condition, and that would include a restaurant or store, or your corner bodega. One that comes up a lot is a loose surface on the floor. So a slippery a rug, which then slides out from under people, is a common one. And dimly lit situations, especially on a stairwell. It also can be that the condition itself is not something on the land, but rather the way the configuration of the premises is. So a defectively designed staircase. So a staircase, for example, without a handrail, or a staircase has uneven stairs. All of those can be considered to be a defective condition.
And you actually made a really good point. You just said dimly lit places. So light can, even if I look around and I think everything is patched up, I have railways, there's no cracks, if there's not enough lighting and as a result somebody falls because they can't see, that's a defect.
Right, it can be considered, a reasonably foreseeable that the lighting conditions that the person who is lawfully at the premises is going to encounter, that's definitely part of the condition of the premises which you control. So if someone encounters it dimly, it may be safe while there's bright lights because you can see what you need to avoid in order not to fall, but if it's dimly lit, that can lead to liability.
So basically, the take from this is go through your house, see what slips, see if the lights are on, see if the rails aren't, if there's something wrong, take the time to fix it because it could lead to something very serious. It could result in injury, a serious injury, and then, you could be responsible or, it could be even fatal. So I think these are really, really good points and I would take the time to just look around and see what's going on. So what about, you hear about all these incidents where, children are involved and they will go to their neighbor's pool and jump in, or, there's some sort of fun toys. Like, how does the law protect the homeowner or the premises owner regarding kids?
Well, Preet, that's an excellent question because there are some special rules about children. Now, I mentioned earlier that a trespasser on your property you only owe a very slight duty to, and they probably can't sue for things that an invited guest could sue for, or at least not sue successfully. It's a very different case with children. There's a doctrine that is current in New York State, as in most of the country, called attractive nuisance. And all that phrase really means is that children, even though they don't have permission to be there, there's a special rule. If there's some condition, and this could be a pool, this could be something that's attractive to children, like a trampoline or a bouncy house, or toys that are left out. Even though they don't have permission to be on your property, if it's something that would invite in a child, and by the way, it doesn't have to be something that's obviously attractive to a child like a pool. It can be an abandoned car or an old washing machine or anything that, because while it looks like junk to us, to a child it can be very attractive. And again, and in fact, that's what the doctrine is called, attractive nuisance. So these kids or young people who are on your land, even though they have no permission, if they come in and get hurt, you can be found liable.
So, how does somebody protect themselves from something like this?
Well, I think this is a case where good fences make good neighbors, especially with respect to a pool. Generally, local and municipal ordinances require that, but it's simply good practice. Right. And certainly don't leave things out that would be attractive to children, including junk and things that you may not think of as being dangerous or attractive to an adult could be attractive to a child. And you mentioned about keeping things safe, and I think it's worth talking about the fact that something in the law called a subsequent remedial measure. If something is wrong and somebody does get hurt, you're protected by fixing the problem afterwards. If there was a loose railing on the stairwell and someone gets hurt, the fact that you fix the railing afterwards can't be used against you. It's called a subsequent remedial measure, and it's okay to do. That
actually is, I think, is good practice, because if somebody gets injured one time and then you're too afraid to fix it, somebody else can get injured and over again. So yeah,
exactly.
if somebody did get injured, I think that is probably the best way to be able to prevent further injuries, and they're not going to hold that against you. Like, see, look, you fixed this problem, then you must be responsible for the injury. And you know what? That takes me to notice. So let's say I have a big house of my dreams, yeah, right? Let's say I live in a big house, right? And I may not necessarily know about every single defect. Maybe it's not a small defect, like you said. Maybe it's a slightly bigger defect that I may not be aware of. And all of a sudden, a guest comes and they fall and they hurt themselves. How am I supposed to know everything?
Right. Well, as I said, you don't have to be the guarantor of someone's safety, so you don't necessarily have to know everything, every nook and cranny of your property. But I think it's important to understand what we mean when we say notice in the law. So it can be actual notice or constructive notice. Now, you're talking about actual notice, and that's where you really literally know about the defect. You've seen it, you've taken pictures of it, you've talked about it. That's pretty rare. Usually when we talk about notice, we're talking about constructive notice. It's kind of like the difference between knowing about something and where you should have known about it.
Right.
And constructive notice is you should have known about it, where if you had taken the time, you would see it. So a good example of this would be a recurring defect. So for example, if you know that your upstairs washing machine, every time a big load goes through, that a puddle is created downstairs from there, even on a particular day, if you don't know that puddle is there, you just didn't see it, or you were out of town and the other person was there. But you already know that every time that washing machine uses, it's created. Well, that might be called constructive notice. So you don't have actual notice, you don't know it, but you should have known it.
And if somebody comes and slips and falls, you should have known, right?
And again, that can be found to be notice, because if you have no notice whatsoever, either actual or constructive, then no, you won't be found responsible, because then it's how could you have known to do anything different and make the place safe?
Right.
So,
and what about, like, you created the damage yourself, right?
Right. So in general, you need to have notice to know about for someone to successfully sue you to be responsible for the damages. But there's no question of notice when it is a condition that the person who owns or controls the property has created themselves.
I think the common theme that you can see there is maybe somebody is trying to make the repairs themselves and may not necessarily have the adequate expertise, right? Like myself, right? And then they fix it, and you're trying to save a couple of dollars by hiring the right person to do it, and now you've actually maybe made the defect larger. So that can also be something serious as well.
No, I think you're absolutely right. I think you should only fix something if you know what you're doing.
So, final question for you is, I understand, whenever I think of this scenario, the party that I let off with, I've been to so many parties, especially in, the Indian community, where it's cramped and then somebody's getting drunk. And what if that drunk person falls down the stairs, right? And it turns out, yes, there's a defect in the stairs. I get it. Maybe it's uneven. But what about the fact that the individual who fell down the stairs was drinking excessively that day? I mean, why would the homeowner be liable still for that fall and for that injury?
Well, I'm afraid I'm going to have to rely on my old standby, maybe. I think you're exactly right that, again, you're not a guarantor of the safety of the people who are in your home or in the premises which you control. So then that would be a big fight. If there's a defective condition, certainly if someone sues, that plaintiff's attorney is going to argue that there was a defect and you should be liable for it. But that doesn't mean that there are no defenses.
Right.
Absolutely. Drinking would be an argument for contributory negligence. Right. That means that the person who got hurt may have been somewhat responsible for their own injuries. Okay. So there are certainly defenses, and the conduct of the person who ends up getting hurt is definitely relevant. Okay,
well, I mean, you gave us so much information. Thank you. I think that the theme to take out of this is be reasonable, look around your house, see what needs to be repaired, and if something does need to be repaired, spend the money on the professionals to do it the right way. Thank you so much, and guys, don't go anywhere. I'll see you guys after a short break. Welcome back. So, as a homeowner or a tenant or somebody who has control over some sort of a property, whether it's residential or business, you can be responsible when others get injured. And we even learned that you even may be responsible to someone who's coming to rob you. I mean, it's very limited circumstances, but don't try to outsmart the robber, especially maybe if you're in a business where you generally do find yourself getting robbed most of the time. Don't set traps where it can cause an injury to that trespasser, okay? Be vigilant about these things because you could be responsible for something like that. But I think the most important takeaway from this show is the attractive nuisance doctrine, which we just said that the attractive nuisance is a doctrine in New York State that says that if a child or somebody who's a minor basically comes onto your property, even if they have no permission to be there, even if you have signs that say go away, I actually don't know about that, but if a child comes onto your property because you have something on your property that attracted them, right? It speaks for itself. It could be as obvious as a pool, or it could just be a car that's sitting in your driveway, and maybe a 12-year-old boy is like, wow, I just want to see how this works, and I know it doesn't, it doesn't really start, but they can injure themselves. If they come onto your property because of something that's pulling them in, and they get injured, well, you could be responsible for that injury. All right, even if they had zero permission to come in. So if you do have, a bigger house, or you have something with the pool, or something that, things are just laying around, where a trampoline would be a good idea, right? Those things where the children bounce up and down. Put up fences, put up a gate, or put those things away when you're not using them and you're not supervising, so that you can be able to protect some sort of an injury. And and then the final thing is, look around your house, just be vigilant about little things. If there's a leak that constantly goes on and it creates a puddle, well, what if somebody, and fix that leak, because somebody could slip on it. Or if the lighting is really bad and you can't really see your way, down the stairs, well, maybe your house and you can navigate it even if there was no light. But what about a guest that may not know, and they can't see the steps, and they miss a step and they fall? So take the time, be vigilant. Obviously, don't go overboard, because again, the test is reasonable, what you can reasonably foresee. So if there's any defects, fix them. I hope that we were able to provide you with some information on what your rights and responsibilities are when it comes to premises liability. Next week, we'll dive into another topic. I will see you next week, same time at 7:30.